Guys, I also have an update. I have a Warby Parker update. Are we in follow-up mode yet? Are we doing follow-up yet?
What's your Warby Parker update?
Dude, so remember those sunglasses that I was hawking on Warby Parker? Or hawking on our podcast like 2 or 3 episodes ago? It was my sidebar. So I ended up getting them, and I just received them, and they're actually not very good. So I'm going to return them.
What's wrong with them?
They feel kind of cheap. They feel cheap. It's kind of disappointing, honestly.
Bummer.
Yeah. I mean, it's all right, but I was expecting more, candidly.
I'm sorry they let you down.
It's okay. I mean, they're going to we'll have a financial arrangement that will be satisfactory for me. So, it'll be fine.
What model is it?
It's that, hold on 1 second. This will obviously be in the show notes.
It's the Yates.
Yes, the Yates. Yeah. I was very disappointed. They just look very flimsy. And the thing is, they shouldn't look flimsy. They definitely look like really nice on, the Warby Parker website. And in person, they're just really underwhelming, honestly.
Do you think you got catfished?
What does that mean?
I don't know. It's like when, someone
You think you're getting a good fish, but instead you get a catfish?
Yeah. Or do you think you got like cat dogged?
I think I got catfish, dude. I think I got
stew
catfished.
Right now.
What kind of stew are you eating?
Lily made it.
Okay, cool. I'm going to the movies tonight, guys. If any of you guys want to go to the movies.
Oh, what are you seeing?
We're going to see Shape of Water this evening.
Oh, I really wanted to see that.
I've heard that movie's pretty lurid.
Lurid?
Yeah, what does that word mean?
Yeah, why? Why do you think it's that?
What does it mean, though? What does the word mean? Sorry.
Like scandalous.
Oh, okay.
Interspecies relationships have always been scandalous.
Think so?
Yeah. I mean, we're all speciest. This is a privilege that we have to be speciest.
Should we start a new segment on the show where Tom or AJ confesses about, their privilege or something? I don't know.
I'm very privileged.
Yeah, but Ruchit doesn't have any privilege.
No, I've privilege. I would agree. Now I don't feel a need to confess it, I suppose, but if somebody were like, "Dude, you're privileged," I would certainly say, "Yes, I am." In multiple ways. But I also don't think of this sort of privilege concept as it does not have to be bad,
Well, I think that in all seriousness, I think that the point of examining your privileges is not to say you're a bad person for having privileges, right? Like it's being aware of the privileges that you have that other people don't have, right?
Yeah.
You want to be both grateful that you have these privileges and not hold the lack of privileges against other people.
I think that's very sensible, Tom.
I mean, that's the entire point of the
Tom's doing a Breyer on you right now. Tom is saying the exact thing that everyone else says, but he just makes it sound more reasonable.
Tom does have that skill. He does have that skill. Yeah, I mean, I agree with what you said, Tom. I didn't realize that that's how people actually wanted it. I thought it was more about, shame on you. You have all these privileges, and you should self-flagellate or something.
Why would anyone want that? It doesn't make any sense.
Well, I think because it's a way to cut people down. You know what I mean?
No, I don't know. I mean, I feel like that's a failure of the movement that you got that impression. Like, I don't think that's your fault. I think that's definitely like the movement's fault. But like, the core thing is that like acknowledging your privilege is about saying like why would you not appreciate how someone else feels, right? If someone else has like genuine pain, right? Like why does someone else have this pain or this apprehension that you don't experience? And is the answer that they're crazy, or is the answer that they have circumstances that you don't? Right? I mean, I think like that's like the core essence of what check your privilege means. The other thing I think is that, when you wonder why someone is not successful, right? oh, like, why don't you own 666 Fifth Avenue? Like, what are the, like, why are you so lazy that you can't even buy a Midtown office building? And the answer is that, like, my dad never went to prison. Like, I never had the opportunities that Jared Kushner had. Like, my dad never hired a prostitute to sleep with my uncle. And that's why I don't own 666 Fifth Avenue,
Is that really the reason, though, AJ?
Yeah.
Or is it because you chose a life of government service?
But I think one leads to the other, right? Like, I think those are like the same thing.
Hey guys, can we do our sidebars first?
Yeah, why not? It's the 50th episode. We can do whatever we want.
Oh my God, AJ, don't go around telling people that.
I mean, it's right there. So Rich doesn't subscribe to the show in his podcast feeder, so he doesn't like understand. But when it shows up in your podcast, it's like 50 and then a hyphen and then everything we know about whatever it is we know. Tom, you really like changed up the Google Doc. What's happening? Why is it all colorful?
I mean,
why does that require a
I just felt like we needed to differentiate. I felt like you guys, didn't. Well,
and why are you laughing at Tom's feelings? Why don't you understand where he's coming from on this?
Ruchit doesn't use the Google Docs, so I guess it really doesn't matter. But like, I when I work with a Word document, I like to have I like to tag the various like levels. So like I like having heading 1, heading 2, and I like on the sidebar to have the sort of hierarchy of the document.
Yeah, of course. Everyone likes that.
Do they?
Yeah.
Do they?
Everyone likes that.
I don't
That's like
think
great. It's like uncontroversial.
I don't really even know what Tom is talking about.
I think that's the more like default status quo position. I think most people have no clue what styles are.
I am the everyman.
Or how to use the style. Like, once you start using styles when creating Word documents, it's going to revolutionize your life.
Actually, Tom was the person who told me to do that. And I made my own like personal template for pleadings at work, and it's like the best.
Mm-hmm. Yeah, it's great.
One of the things that I really liked back when I was at Baker Botts is that the secretaries were experts in all of this stuff, and so I never had to learn any of it. And so I'm not self-sufficient in this way like Tom is. But I loved when they set all that stuff up. It was awesome. Our assistants were incredible at the Botts.
At my old job, my secretary got kind of offended because she actually is like genuinely very good at doing like Word template stuff and table of contents. But I was like so particular about how it looks that I would just do my own anyway. And she like eventually got offended.
I just like to automate. I think that's the beauty of styles is in Word is you can automate all of that stuff, right? Like if your headings, if you want to change the way every single heading looks, you can do that with just one action, as opposed to like going and finding each heading and being like, okay, I need to like format the font size to be such and such, and now I gotta italicize it or whatever BS. Like,
all right. So what we were going to talk about? You were going to talk about something. You wanted to do sidebars first.
Yes. So I've got a good sidebar. So this is an article written by Leo Katz called "Blackmail and Other Forms of Arm Twisting." It's entertaining because what I like about this is that he kind of it's easy to read. I think even from especially from a layperson's perspective, there isn't a lot of law per se. It's more a lot of hypotheticals concerning blackmail. And what I like about it is it's kind of a preview into the type of stuff that law school hypotheticals are made of and created for law students. So to sort of set this article up, he gives like a classic example of blackmail. Pay me $10,000 or I'll reveal your affair to your wife. Okay. And he says, well, look, if you were just to reveal the affair without asking for any money, that wouldn't be blackmail. If you were to threaten to reveal the affair without asking for money, that wouldn't be blackmail. Or if you just demanded $10,000 and didn't say anything about the affair, that also wouldn't be blackmail. So he's like, isn't that weird that like this, it's everything that makes up the crime
The
of blackmail,
components.
the components of blackmail are all legal, right? But when you combine them together, you have this illegal act, right? And he goes through and gives like kind of cool little examples. So another example he has is, Mildred and Abby are aspiring actresses. They look alike and generally go for the same parts, but Abby always gets those parts when the two are in competition because she's just a little better than Mildred, right? There's this one part that Mildred really wants, and she knows that if Abby shows up, Mildred won't get it. Now, if she calls Abby up and tells her, hey, I'm going to tell your husband about your affair if you show up to this audition, that is blackmail, right? But what if she calls up Abby and says, you know what? I've written out this letter to your husband, and I've included all the details of your affair, and it's due to arrive via FedEx on the day of the audition. You know, if your husband finds out, he'll know all about your affair. If he finds this letter, he reads it, he's going to know all about this affair. And so Mildred knows that Abby's going to stay home from that audition to try to intercept the letter instead of, going to the audition, right? Is that blackmail?
No.
No?
It's not blackmail. It's probably something else, but it's not blackmail.
Maybe. Who knows? Right? So, we have what about if you were to go and say, pay me $10,000 or I'll seduce your wife? Is that blackmail?
Yes.
Pay me $10,000 or I'll persuade your son that it is his patriotic duty to volunteer for combat in army.
Yeah, that's blackmail. That's actually in the Texas Penal Code. That's called theft.
Well, yeah. So ignore the technical definitions for just a second. I mean, everyone knows what blackmail is, but like if you say blackmail by extortion, you're eventually going to use too many legal words to. What I liked about this article is that it's so easy to understand from a lay perspective, right? So let me give you another example. Pay me $10,000 or I will give your high-spirited, risk-addicted 19-year-old daughter a motorcycle for Christmas. Is that blackmail?
Yeah.
Yeah.
Pay me $10,000 or I'll hasten your ailing father's death by leaving the Catholic Church.
Wait.
Yeah.
Yeah.
Okay, so let's say you steal a Rembrandt from a museum and you send a letter to that museum saying, pay me $10,000 or you'll never see this painting again. Now, for the theft of the Rembrandt in the first place is obviously theft, but is the second, pay me $10,000 or you'll never see the painting again, blackmail?
Yes. So to me, so how about this? How about this example? So what we focused on is...
The answer actually is no.
Oh.
This was a hypothetical from a German court, and the court said the second one was a sale, but he's guilty of theft.
Okay, so how about this? Pay me $10,000 or I will convince your teenage son to go to college. I know you don't want him to go to college. Like, let's say that's the thing you don't really want. You know what I mean?
How's that different than pay me $10,000 or I'll convince your son to join the army?
So it's not. That's kind of my point. Is that, it doesn't have to be something that, necessarily the society thinks is good or bad. That's not what's relevant. It's whether it is a threat to you, whether it's an outcome that you want or that you would like to avoid. And I'm asking you to pay me money to avoid that outcome.
What I overall like, what I like about this article is that it's just kind of like a little like, this is how the law works, right?
Yeah. Yeah. I like it, dude. I mean, does this mean I need to have a sidebar right now? Because I don't have a sidebar right now. Because I was...
Yeah, that's how it works.
Yeah, it's your turn for sidebar.
But I thought we'd do these at the end. So, I'm not, ready.
Tom asked if we could do them at the beginning, and then you said yes.
Well, Tom asked if he could do his sidebar.
No, I said,
right
can
now.
we do sidebars at the beginning?
I definitely didn't.
Can we play the
interpret it
tape back? AJ, can you splice in the question at the beginning?
I mean, it's possible I will, but most likely I won't. All right, I'm going to do my sidebar. Are you ready?
Hit it, dude.
What's your sidebar?
All right. When I was in college, my first semester of college, there's this guy who lived in my dorm, and his name was Matt Ingebretson. And a couple years later, we were like friends a little bit. We were fine. Like, we knew who each other were. A couple years later, I was at a comedy club in Austin, off 183. and I bumped into Matt, and I was like, "Hey, I haven't seen you in a couple of years." He's like, "Yeah, I'm about to move to LA and become a comedian." And I was like, "Oh, dang, like, I admire that conviction. You're like a pretty funny guy." Anyway, now he like has a TV show on Comedy Central, and it's astoundingly good. It's like one of my favorite shows of all time.
Whoa.
Which is like really
That's awesome, buddy.
Yeah. He really like did it. You know when someone like really does it?
Yeah. Yeah, that's awesome, dude. I'm always like very, very happy when somebody just goes and does it. You know what I mean? Like it's there's like always like 5,000 reasons not to do something. And so the mere suspension of those series of thoughts, to just sort of pursue that is like I don't know. It's really, it's admirable, of course, but it's definitely like inspiring, I think. So that's cool, dude.
He really did it. Isn't that astounding? This show is like amazing. It's one of my favorite. It's one of my favorite like 20-minute comedies of all time. He's
got a Wikipedia page and everything now.
I know. Can you?
This is making me want to like really sell my couch. Like just do it.
Isn't that cool? So he's like very successful. So the show is called Corporate. It's on Comedy Central, and Matt Ingebretson and Jake Wiseman.
Oh, I saw an ad for this.
Yeah, they star as junior executives in training at a company called Hampton DeVille, which I think is supposed to be like a take on like, I mean, pick your like mega conglomerate, right? Like Berkshire Hathaway or Koch Industries or whatever. And they're like, it's like Office Space, but for millennials, right?
Huh.
I think that like the Gen X, like Mike Judge sort of disaffection, which was sort of that like the world is good, but our bosses are bad. And I think the real message of Corporate is just that the world is bad, which I think is like a real difference between Gen Xers and millennials.
That's an interesting observation. Can you expound on that?
Yeah. I mean, think about like Office Space or like any of the Mike Judge stuff, right? Or just like other works from that time, like Coen Brothers works or whatever. I mean, I think there's this core message that like baby boomers are bad, but that like the I think the real message of Mike Judge or the Coen Brothers or other people is that like baby boomers are bad and the world is stupid. Right. Like the world is dumb. The world is like ruled by indifference, but that, there's some point to like being alive. There's like something to hope for, right? Like you can aspire for some sort of like happy life, right? Like Bobby Hill is like full of like a joie de vivre, right? Whereas I think like the core message of a lot of sort of newer generation shows, right? Like Broad City or Corporate or whatever is actually just like the world is bad. Like there actually isn't much point in hoping for things to get better.
So now that you say that, it actually makes me think about the arc of Jon Stewart's career a little bit, or really his career being a host of The Daily Show, which is so probably about a year or 2 years before Jon Stewart went off the air. Now, maybe this was more a change in me than a change in Jon Stewart, so I'll preface it with that. But I do think it was a change in Jon Stewart, is he just got so much more like what you're talking about, AJ, in the sense that the cynicism became so deep and pervasive that it actually stopped being, one, fun to watch, and two, became like a little bit of a downer. And I found myself, laughing a lot less. You know what I mean? And that's one thing that maybe is a little bit different with like Trevor Noah, for example, where he, I feel like his cynicism is not so deep. But I don't know if that's at all related to sort of what you're saying, but that idea of like the world is just plain bad and there's nothing to hope for, which is obviously, a big part of Tom's "I'm going to go to sleep and die" message that he
that is not my message. I'm not going to sleep. I'm going to lay on the floor and wait to die.
Right. My bad.
There's no like proactive, trying to kill myself. I'm not suicidal here, guys.
So, I mean, to put a fine point on it, I think that the Jon Stewart thing maybe a slightly different phenomenon. I think a lot of the problem with I think the reason why Jon Stewart got so depressing towards the end of his career is that like it was like obvious when Bush was president why things might be bad. Like it was like very like obviously things are going to be bad while Bush is president. That's not surprising. But Obama was president for 8 years, and in a lot of ways, like things got worse, not better. You know, like I think that one of the things that Gen Xers like had to hope for was that eventually the baby boomers would go away. Like eventually the baby boomers wouldn't be in charge anymore. And I really sort of thought that like George W. Bush was going to be the last boomer president, and that, oh, you know, like there was like this like momentous sea change in how our country is organized. And then actually it turns out that like in 2016, your choice was 2 more baby boomers, and like the worst one won. Like the one that was like particularly baby boomery about it.
Yeah, I mean, as sort of a general optimist, I guess I find it hard to embrace that view. But the nihilistic aspect of it does trouble me, and I think you're right. I mean, I'd never quite put a point on it the way that you did here, but I do see the nihilism in a lot of different places, and it's really not good. Because I mean, if you think about it, like we have nowhere near as much reason to be nihilistic as like, you know, the vast majority of people in history, like somebody growing up in the Dark Ages, you know what I mean? Or someone growing up in the time of like, you know, World War I or World War II for that matter, you know?
Ruch,
yeah.
Would you say we should check our privilege on that front?
No, yeah, I think we should think about why we should be grateful about this moment in history, and that's I see like I see some real reasons to be a little nihilistic, but I think there's like way more reasons to not be nihilistic than there are to be nihilistic. You know,
I don't think it's quite the same as nihilism.
Okay, why not?
It's hard to describe. I don't think nihilism is the right word, or at least I don't think the way that I'm imagining you interpret nihilism is the right word, right?
The life is meaningless. There's no point. You know, extreme skepticism. I mean, these are some of your dictionary.com definitions, but also that I would agree with, you know? You know, here's another one. This is just dictionary.com, or maybe it's Wikipedia, but the doctrine of an extreme Russian revolutionary party circa 1900, which found nothing to approve of in the established social order.
So I think probably the better word is hopelessness.
Yeah, which is also an odd thing, I think, to feel in this time. You know, it's a weird thing to feel powerless, at least to me, because you don't have enough power. Because it's one thing to have no power, right? So, like, if you were living in, you know, Nazi Germany or like any of these like very, very bad times in history, I think it would be like a fair thing to say, listen, I have like literally no power and literally no control. It doesn't seem like that's one of the times today. It seems like people don't have as much power as they would like. They don't have as much control as they would like, or as much influence. And there are things in society going on that they don't like. Which is a fair point. That's probably true of all historical ages, including the extremely normal ones.
Anyway, what's your sidebar?
Man, that was good, dude. That was a good discussion, guys.
Richard's sidebar is our podcast. Richard's sidebar is everything we know about the American Heartland, episode 50.
Yeah.
Rich
maybe
really
we can call
recommends you listen to this episode. So here's the deal. I put a bunch of stuff in the Google Doc. There's a lot of stuff in the Google Doc.
Wait, Ruchit didn't have a sidebar.
No, his sidebar is Yuka, episode 50.
It does seem like I'm ripping the listeners off. Okay, let me postpone my sidebar till the end. I don't think my sidebar should be this couch that I need to sell. You know, for example.
Can we go backwards in our usual episode order this time around and start with the Supreme Court predictions and then review Supreme Court cases that have already come out and then go to the main topic?
Ooh, let's keep going. I love this.
Yeah, go for it.
Okay, so let's do a Supreme Court prediction. This is Minnesota Voters Alliance versus Mansky. You guys might have heard of this case. This is the question presented in this case is does the Minnesota law banning political apparel at voting locations violate the First Amendment? So basically, Minnesota has this statute that says a political badge, political button, or other political insignia may not be worn at or about the polling place on primary or election day. Basically, it prohibits, you having a sign that's, political on your shirt, or a button that says vote so and so, that kind of thing, right? And this case arises out of the 2010 election, when a man attempted to vote wearing a "Don't Tread on Me" flag and a small button that said "Please ID me." And the election worker told him that he would have to cover up. He refused, but eventually they allowed him to vote wearing the button and the shirt, but the election worker wrote his name down in a book as an offender. At the Supreme Court, the question is whether this polling place can be a free speech free zone, right? So no speech zone, similar to the Supreme Court Plaza or, areas like that.
I think the concept of a free speech free zone on public property is really dumb, but that's just my opinion.
Well, I mean, let's play that out, right? Like, do you think court routes? Do you think courtrooms should be people should have a freedom of speech right in a courtroom?
No, I mean, I think it's a disruptive. It has to do with like disruption. I think more than anything else. I guess. So I think it should be narrowly tailored, right? So like the Supreme Court Plaza, the fact that you can't protest on the Supreme Court Plaza, like what the hell?
Yeah. Well, I mean, you can protest on the sidewalk. I'll link in the show notes this article about why you can't protest on the Supreme Court Plaza. That is so like it does seem strange. Yeah. But so like this is sort of a line of cases where they basically say the Supreme Court has said, the government can place reasonable time, place, manner restrictions on where you can exercise your right to free speech, right? Like, yeah, you have a right to protest and hold a rally, but you don't necessarily have a right to protest and hold a rally at any time of your choosing, right? Like the government can say, you know what, we need you to have a permit to hold this rally. We're going to have to secure law enforcement to make sure that your rally doesn't get out of hand. That sort of restrictions on your speech have been upheld time and time again.
So the idea of a free speech free zone is like long held in the Constitution, right? So the court has a 3-part framework for government property, right? So the government owns 3 kinds of property. The government owns public forums, limited public forums, and places that are not public forums. So, right, so in a public forum, that's like a public park or a place of like general accommodation, and that says that anybody can go to a public forum and conduct any kind of speech that they choose to. In a limited public forum, the government would have an interest in some sort of control over who has access to the forum, but it has to be content neutral. So an example of a limited public forum would be a university campus, right? So you've got an auditorium where student groups can schedule speakers, and the government has an interest in sort of making sure that the area is secure and in having some sort of control over who comes to speak. But ultimately, the government can choose to allow speakers to participate or not participate as long as the government's actions are content neutral. And then finally, you have places that are not forums at all, right? So the floor of the U.S. Senate is not a public forum. You don't have any right to go to have access to the floor of the Senate and conduct any sort of speech that you choose to, right? It's not a place of any sort of public accommodation. Right, but like the floor of the Senate being a free speech free zone is like a long-standing constitutional principle, right? Like that's not controversial.
Okay, so continue, Tom, on that.
Yeah, well, I mean that's pretty much it, right? Like, do you think that this polling booth is more like the the Senate chamber or the Supreme Court Plaza or these other areas where we have said, you know what, it's okay to not have, a right to speak whatever you want at this moment.
So the specific restriction here is you can't wear politically themed apparel. So no buttons, no T-shirts, and
Or insignias.
or insignias. So who gets to decide whether it is politically themed or not?
That this was actually a line of questions at the oral argument as to who exactly gets to decide. The initial, I guess I'll give the state's perspective. The state said that the first person who gets to decide is the person who wears the insignia, their decision to wear it or not. The second person who gets to decide is the person the election worker, and there are usually about 4 of them in these voting places, and more if it's a busier day. And then they have this system of and so what these election workers do is they first tell you, hey, you're wearing a political insignia, that's not allowed. You got to cover up if you want to vote. And if you refuse to cover up, they'll do what they did with this guy and write his name and address down in a book as an offender. And then later, there's this series of election judges who are trained in what constitutes, I guess, political insignias for the purposes of this law, who adjudicate this issue and determine whether or not they actually violated the law. And if you are found to have violated the law, then you are fined up to $300.
So here's my take. The government has an obvious compelling interest in prohibiting electioneering at a polling location.
And before there's one other detail that you should know that I think is pretty important. A lot of states have a law that says, you can't do this. You can't have political signs, insignias, buttons, that sort of thing within 100 feet of a polling place. You can't basically electioneer within 100 feet of a polling place, right? And that has been upheld to be constitutional under a case called Burson v. Freeman, arising out of Tennessee.
And what constitutes electioneering? Does that include
so displaying political signs within 100 feet of a polling place. So this statute at issue, the Minnesota statute at issue, is actually a 3-parter, right? The first part says that you're not allowed to display political signs or the like within 100 feet of the polling place. The second part says you're not allowed to hand out badges, buttons, or other political insignias within 100 feet or as people go into the polling place. And the third part is the people that are going into the polling place can't actually wear buttons, badges, or political insignias in the polling place, right? And the first 2 parts have been found to be generally constitutional. That you can create a buffer zone from the polling place to prevent people from electioneering.
So the government has an obvious compelling interest in prohibiting electioneering at polling places, and I don't think that's controversial, right? So the government would have an obvious compelling interest in preventing someone from showing up with a bullhorn and screaming at people as they vote for Jane, or whatever, right? Like, obviously the polling booth is not an unlimited public forum, right? Now, the polling booth is probably not even a limited public forum. So, right, it's not like the government exercises some control over like who are the speakers there, and is like weeding out who's speaking and who's not speaking there. Like, I don't think the polling booth is a platform for any sort of public demonstration, political or otherwise. And so the government doesn't have any obligation to have like a content neutral speech framework for polling locations, right? I think the polling booth is probably one of the best examples of an area where there isn't a free speech right.
Yeah, I think I'm with, I very rarely say this, but I'm with Justice Alito on this one. The idea that, first of all, like, who gets to determine whether you are, whether you are wearing a political shirt or not a political shirt? Is it actually political at all? So, during the oral argument, there was a good exchange between Justice Alito and the lawyers from Minnesota, where Justice Alito was asking, what about a shirt that says all lives matter? What about a shirt that says the text of the Second Amendment? And the line is, in terms of what is political speech and what is not political speech, is like on a T-shirt for that matter, is like pretty damn arbitrary. I think like it's one thing to say you can't scream at people in a polling booth, because it's, pretty reasonable to say that if you electioneer in the polling booth by, screaming, let's say, or even speaking for that matter, hey, buddy, you should go vote for so-and-so. There's a decent argument to be made for, I think, that potentially you're intimidating somebody. Whether AJ wears a Planned Parenthood t-shirt, you know what I mean? Or I wear a everyone should read a David Brooks column every now and then t-shirt. Or maybe if I even include a paragraph from a David Brooks column on my t-shirt, let's say, as part of my extreme moderation that you guys always tell me I practice.
What about like a hat or like some, gigantic thing with flashing lights and, nothing that makes noise, let's say, but like flashing lights and, a big arrow pointing at like, vote Trump or whatever, or vote Hillary or vote whatever.
Yeah, I think if it's like, distracting, I suppose, you know what I mean? And I agree that,
I mean, who gets to decide what's distracting and what's not?
Well, maybe flashing lights, right? Like maybe flashing lights or audio.
I don't think Alito's argument works the way you think it does, right? So what you're saying is that there's like a line drawing problem, and there's this sort of like there are the vagaries of what may or may not be political speech, and so it would be very difficult for the government to implement. But that cuts like both ways, right? The government has an obvious interest in prohibiting electioneering, and there may be some cases on the margins where it would be difficult to say what's electioneering and what is for the most part harmless or doesn't fall within the government's compelling interest. But overall, right, like when you have line drawing problems like that, I think your instinct should be deference to the legislature, right? Like the legislature has identified the legislature has identified that wearing political slogans as a disruptive form of electioneering, and the legislature has identified a framework of various rounds of individuals who have roles in determining what may or may not be permitted. And so it seems to me that the instinct of the court, when in doubt, like if your whole argument rests on there's some sort of line drawing problem, it would be difficult to know what is the right thing or the wrong thing, that the line drawing should default to the wisdom of the legislature.
That's where we disagree. I think it should default to the First Amendment, which is, you want broad speech rights, not speech rights that are restricted by the legislature, and let's just defer to the wisdom of the legislature on your speech rights. I think that's absolutely the wrong way to approach it. I think the fact that substantial line drawing problem exists in this case, and the fact that like the lawyers for Minnesota can't even properly define what is considered electioneering, what is considered political speech. I mean, these are people arguing before the Supreme Court, and they can't define it, and they're expecting that thousands of voter registrars, or not registrars, but volunteers at high schools and elementary schools and daycares and senior centers are going to know how to administer this law. I think
you're reading really deeply into a very limited exchange in oral arguments, right? Like one guy in one of the most stressful extemporaneous speaking situations that you could imagine wasn't able to answer a question to your satisfaction, and suddenly the entire state's law is unconstitutional. I think like places a real overemphasis on oral arguments, which actually are not that important in the deliberations of the court overall.
Well, no, hold on now. If we can't, if the law is the law should actually define what you are allowed to do and what you're not allowed to do, right? And if the law, one, fails to do that, and two, there's no really good ability in terms of explaining where the line drawing falls. I mean, listen, I sympathize with this guy, right? Like we've all, been in a situation where we were on the spot and we weren't able to come up with, the best answer, and we didn't do our best possible job, right? And I totally sympathize with this guy as it relates to that. But I actually think it's less his fault and much more the fault of the statute, which doesn't define, it seems to me, what you're allowed to do and what you're not allowed to do.
It says you're not allowed to wear shirts or buttons with any slogans on them, or any like political slogans.
Well, I mean, what if this comes back to a debate that we've had before, I think, which is, a lot of things are politics. A lot of things are political, right? If I wear something about like lower budget deficits, comma, please, is that electioneering?
Yeah.
What if I wear a shirt that says, just do it, go vote? Is that electioneering?
No.
Okay. So anything that discusses any issue or that might tangentially be connected to a political issue, which in public life is a lot of things, wouldn't be considered electioneering. Or would be considered electioneering, rather.
What if your shirt said, "Pay me $10,000 or I'll seduce your wife"?
Not electioneering. Not electioneering. Probably, but I don't know.
Probably, yeah.
Anyway, I'm personally troubled by a lot of these restrictions around electioneering, and I think the real place to do it is around like areas that cause like voter disruption or voter intimidation. Do you know what I mean? As opposed to a broad law that basically says that no one is allowed to speak.
All right, you ready for predictions?
Yeah, what's your prediction?
Predictions.
My prediction, the right answer is that the Minnesota law is upheld, and my prediction is that the Minnesota law is struck down 6-3.
My prediction is, well, first of all, the right answer is that the Minnesota law should be struck down. And I think what it will end up is, I want to say 7-2. I'm going to go with 7-2. Kagan's going to come on board. So it's going to be all the conservative justices plus Breyer plus Kagan. Who does that leave, actually?
No, I think of any of the justices, Breyer is the one most likely to uphold the Minnesota law.
Ooh, interesting.
Yeah, because Breyer, I think, like more than any of the current justices, is like a deep believer in like the technocracy of the government to be able to solve problems.
But of the federal government, I don't know if he necessarily believes that of the state governments, does he?
No, I think he does. I mean, I think he really thinks that like an empowered bureaucracy like really could solve a lot of problems, right? Like I think Breyer is for example, the justice who's probably like least skeptical of Chevron deference or something.
Dude, so Sotomayor, who would be the other dissenter under my
Breyer.
Oh.
Breyer and Sotomayor.
Yeah, we just talked about that.
Oh, right. Oh, yeah. Okay, yeah. So actually, I think it's going to be... Okay, I'm going to stick with my 7-2. I think Ginsburg is definitely going to nix this shit.
Yeah, Ginsburg 100% is going to vote to strike down the Minnesota law.
Yeah, I think it's going to be Ginsburg and Kagan that come along. I used to think that, gosh, maybe it's even 8-1. I don't know. No, I'm going to go with 7-2. I think Breyer's going to dissent. I think Sotomayor is going to dissent.
All right, Tom, what's your prediction?
I think it's 8-1 Voters Alliance.
Who do you think Breyer is the only dissenter?
Breyer, yeah.
Has Breyer ever written a lone dissent? I don't know that, like, I'm sure it like must have happened, but there isn't one that comes to mind ever.
I think he has. I feel like he has.
All right. Well, okay. Should we move on? We've got some old predictions. We've got some old predictions that the court came down with. You want to talk about them?
Oh, we can if that's what you want to do.
So there are 3 that we predicted before, and I think we should probably talk about like one of them. What do you want to talk about? Patchak v. Zinke?
Sure. Well, we already talked about class. I thought the only 2 I don't think we've talked about was Patchak and Jennings v. Rodriguez.
Here's the deal with Patchak v. Zinke, right? So this is the case where the Secretary of the Interior, Ryan Zinke, had been exercising his authority to hold certain land in trust, and someone didn't like it, and they sued. And then during the pendency of the suit, Congress passed this law that basically said any action in federal court relating to this particular patch of land has to be dismissed right away. And
yeah, this was the boring one.
It was like it was fairly obvious that the law was intended to affect just this one particular lawsuit, but nevertheless, it was sort of written in this facially neutral way where you could sort of trick yourself into thinking that it was actually, it was not just a law about that one thing. So anyway, I thought the thing that I thought was like really interesting about this case is that there's actually no majority opinion. The court split into a plurality for the opinion of the court, and then a concurrence that took a completely different approach but the same outcome, and then a dissent. the opinion of the court, and I think the best outcome is the one written by Thomas. And what he says is that, the Congress is able to remove the jurisdiction of the courts whenever it wants to. And here in this case, it exercised that authority to remove jurisdiction over lawsuits relating to this like particular patch of land. And that's fine. And, Congress is allowed to do that. And then, when there's a change in law during the pendency of a suit that removes the jurisdiction of the court, then the court has to dismiss it, right? So Thomas makes it sound like this is like not a controversial or difficult case. The dissent, meanwhile, which is Roberts, Kennedy, and Gorsuch, is like, well, this law seems like one thing on its face, but if you really think about it, like here's what the law is really doing, and here's how to really think about it. And it was like a particularly non-textualist decision. And in fact, it wasn't really an originalist decision, right? I mean, you could think of it as an original intent, but definitely not an original meaning, right? Interpretation of the statute, right? It was very sort of this like legal realism idea that like, we should be thinking about what does the statute really do, not just what does it say. Anyway, I found that like super interesting.
Ruch, what do you think?
Guys, can I admit something?
Yeah. What?
I don't know what case you guys are talking about. I don't have a memory of what that case was.
Do you?
Can I add one thing? Go ahead, Tom.
Well, I was going to say it's a case that has a little complicated procedural history. I think the one thing that people should take away from this case is that Zinke, the Department of Interior, has his own personal flag.
When are we creating our Heartland flag?
I guess at the same day we create our Heartland coin.
We need to do that before May, dude. So like, let's try and do that soon.
Yeah.
Anyway, the thing I wanted to highlight was that like Thomas is terrible, and I think most of the time he gets it wrong, but he actually is sort of devoted to his like extremely rigid and narrow textualist interpretation of the law, whereas like Roberts and Kennedy and Gorsuch just want to get whatever answer they want to get. Like Thomas is consistently wrong, but at the very least he's consistent. I think there's like something to be said for that. So I thought that was like an interesting take on that case. And also the other thing I like about that case is that Ruchit got the prediction wrong, but I got the prediction right, and Tom got the prediction right.
Oh, I don't like this case at all. Was this one of those situations where Thomas was very clearly wrong, I was very clearly right, and only because of convenient bedfellows does AJ like what happened?
I don't know.
No, like what happened was Ruchit predicted 9-0 for Patchak, and I predicted 6-3 for Zinke, and then the result was 6-3 for Zinke.
That is some BS. I can't believe that Thomas did this.
Sorry, dog.
Yeah. So the other case that came back was Jennings v. Rodriguez, and if you guys remember, this was the issue in this case was whether non-citizens have a right to bond hearings in immigration and deportation proceedings. And in a quasi-plurality opinion written by Justice Alito, the court found that they do not have detained aliens do not have a right to periodic bond hearings during the course of their detention. So there we go. Those are the two cases.
Whoa.
Oh, that sucks. Why did they? That's a terrible decision.
They did. That's not exactly what they found, right? I thought that they said that like they needed to remand it to be processed with a different standard, but that the original opinion saying that they are entitled to bond hearings was not like thought through. All
well, what it says is that the statute at issue doesn't give detained aliens the right to a periodic bond hearings during the course of the detention, and the Ninth Circuit misapplied the canon of constitutional avoidance in holding otherwise.
Bummer.
Okay. I don't know if I like this ruling.
Ruchit also got that one wrong too. If it makes you feel better.
So it makes me feel worse. I was having like a great run until very recently. In fact, it was beginning to seem like you guys have been practicing law all this time while I haven't and have learned nothing. But the facts caught up to me. I feel like Donald Trump might feel someday.
We're only 3 cases in. We have a lot of cases to come back, and
That's true. But last year I was doing great. Like in the early days, you know what I mean? Like for like 30 or 40 cases, I was like, right up there with you. I think I was doing better than AJ for sure. And I think I was either close to Tom or maybe even better than Tom.
You want to talk about this Arizona case?
What Arizona case?
So this is the case that just got filed. So the Arizona legislature passed a no-BDS law.
What is BDS?
Rich, what's BDS? Tell Tom.
Oh, so this is it's a divestment law.
You see, you've got your sadists and you've got your masochists, right?
Yeah. So BDS is a movement to divest from investments in occupied territory. So every word other than investments that I've said here is a highly charged term. Okay.
So it stands for boycott, divestment, and sanction. And the idea is that there are people who think that Israel's government is illegally occupying areas of Israel that they're anyway,
or Palestine or the West Bank. I mean, every single word that AJ and I just used
very
is
charged.
Highly charged.
Yeah.
The word occupy is very charged. All of these words are charged. I mean, I can't even believe we're talking about this in today's day and age.
So people think that the government of Israel does a lot of stuff that's illegal, and they advocate for a boycott, divestment, and sanction of Israeli businesses that they view as supporting the bad things that happen in the things that Israel that they view as bad. Anyway.
Oh my gosh, are you kidding me? Like we're probably all going to get fired from our jobs. Like Tom's going to get fired from his job for like even discussing this issue.
Okay. So Arizona passed a law that said that no subdivision of the state was allowed to contract with or participate in or give any money towards anyone who supports the BDS movement. Arizona passes the statute, and so then the Arizona State University adds to its form contract for all contracting. It adds some form language that says, and as signing this contract, you agree that you're not going to advocate for the BDS movement. And so the Muslim Students Association at ASU invited a speaker, and the university says, okay, anyone who speaks and gets paid to speak on our campus has to sign our form contract with our boilerplate. And they were looking at it, and part of the boilerplate said that you can't advocate for BDS. And so the speaker said, well, I can't sign the contract and because I do advocate for BDS. And so he wasn't able to speak on campus, and they weren't able to have their event. And so now there is a lawsuit with CARE, which is the Council on American Islamic Relations, and the American Muslims for Palestine group are suing the university, Arizona State University, and their lawsuit is basically that the state of Arizona's anti-BDS law is a violation of the First Amendment and the 14th Amendment.
I mean, the way you've described it seems like they've got some ground, right? Like, the state is basically saying that you can't be involved in advocating for a particular cause. Like, that's not viewpoint neutral. That's a limitation on speech.
Well, hold on a second. So, but that's only if you want. So it would be one thing to say you can't. So maybe give me some clarity on this, AJ, because you know this better than I do. But is the state saying that if you want to take money from us, you cannot advocate for X? Right? So you cannot say X. Or is the state saying if you want to come speak on our property, aka the university campus, you agree not to say X?
So here's what the lawsuit says. So on February 22nd, 2018, the leadership of the Muslim Students Association invited Dr. Hatem Bazian to give a guest educational presentation on campus. To host an event, the Arizona Board of Regents and Arizona State University require that student organizations pre-clear the availability of physical facilities and that the outside speaker sign the university standard speaker artist performer agreement. The standard agreement was amended to include a paragraph with some boilerplate language on not boycotting Israel, right? And so the way the lawsuit makes it sound is that this person wasn't able to speak on the campus because
they could not sign that.
Right. Now, here's what I think, right? If Arizona State University said that no one who advocates BDS is allowed to speak on our campus, then I think that would be a problem, right? I think that would be a First Amendment problem, right? But if Arizona State University is just saying that no one who advocates for BDS is allowed to get paid by the university to speak on the campus, then I don't think that's a problem, right? Like the state should have pretty wide latitude in whom it contracts with, right? So I actually think like the anti-BDS law on its face is constitutional, right? Like the Arizona legislature prohibiting any subdivision of the state from contracting with or obtaining procurement from someone who advocates for BDS. I think that's probably constitutional.
So as another comment on that, I guess, a lot of states, now I don't know the exact language of the laws, and that obviously matters, but a lot of states have similar laws as it relates to, entities, the state and state governmental entities are not allowed to contract with anybody that does business with Sudan, for example, right? And this was an outgrowth of, what happened in Darfur, right? So there was a massive, nationwide movement, and there's pretty much every state has a law that says that, listen, if you contract with anybody that you as a state governmental entity cannot contract with an entity that also contracts with, Sudan, or that also contracts with Iran, for example, The more interesting thing here might be, do you think that there would be a challenge related to the state's ability to conduct foreign policy? Are the states effectively conducting foreign policy here?
No, I don't think that's
which they're not allowed to do. Yeah.
No, I don't think that's like a real problem.
Yeah, I'm kind of, I don't know where I stand on this one, but I agree with you, AJ, that it would definitely be extremely problematic if the state were to say, if you support a certain view, you are not allowed to express, you are not allowed to come, speak on our campus, or you are not allowed to, say those words on our campus, let's say. That would be a First Amendment problem for sure.
Yeah.
The governmental contracting thing it depends. I guess part of this also depends is the governmental contracting thing, does that effectively become a speech restriction on everybody? Like, in the sense of, like, is that just something that everybody that speaks on the campus has to sign? Because if so, that's like, whether they get paid money or not.
Well, and that's the other issue that I was going to raise is at a certain point, certain governmental restrictions on what their money can and can be used for becomes a tool that in effect suppresses all of that speech when that money is so pervasive, right? Like, let's say we had a system in the United States that offered universal health care, right, to everyone. If you passed a law that says, if you advocate for BDS, you don't get to take part in this great universal healthcare system, then I think, you're going to run into problems where the government is essentially coercing, doing what they cannot do by general statute alone.
Yeah, I actually don't think that's a problem.
You don't think that's a problem?
I think because that standard is like impossible to enforce, right? So what you'd be saying is that like the court needs to appoint a special master to make sure that there's sufficient investment in like white supremacist Medicaid contractors, right? Like you could, the alternative, right? Like the flip side is to like have someone sit there and micromanage government contracting to make sure that there are like enough white supremacists getting government contracts so that you could say the government is not like imposing some sort of like viewpoint discrimination in the contracting business. And the whole thing like breaks down as soon as you try to implement it, right? Like I think basically when the government is contracting, it's not the government, it's just participating in commerce.
So and that's so you wouldn't have then you don't think it's problematic if the government was to say, hey, you don't get universal health care if you if you are someone that supports Planned Parenthood, let's say.
I mean, I think that would fail rational basis test.
Okay. How about sort of like the Texas law, right? So we've talked about this, I think, before, where Texas is ban on Planned Parenthood. Not ban on Planned Parenthood, but says that if you are a organization that advocates for certain things, doesn't Texas have this law? You're not entitled to receive money from the Women's Health Program or something like that, which has effectively blocked out Planned Parenthood.
No, that's not. No, they said it was organizations that or whose affiliates provide abortions aren't allowed to participate in that program or something.
Okay. Well, what if, then go with my hypothetical for a moment, where they said, listen, if you're an organization that advocates for abortion, we the government are taking a policy view that, you're not entitled to provide women's health services because we think that's harmful to women.
I think that probably also fails rational basis.
How's it different than saying, if you want to come, if you want to get paid by the university to speak on our campus, you can't advocate for BDS.
Yeah, I don't know if rational basis is the right tool.
Yeah, that I would agree with that too.
I think the right tool is whether they're, and I'm not saying this is, it should be some sort of like generic, like, applied to everything, but I can certainly see a court leaving open room for a certain category of cases where, the government contracting becomes coercive of speech.
Anyway, I think this is like a tricky case, right? I mean, I think sort of your instinct, I think there are a lot of folks whose instinct would be that, like, university campuses don't have any obligation to host problematic speakers. Right. And there are a lot of people who think that universities have an obligation to host any speaker, that there's like no speech that should be off limits on a university campus. And I think sort of the right answer is somewhere in between, right? Anyway, so okay, put it this way, right? What I like to do as a thought experiment often is like work from the extremes, right? So often when you have a problem, there's like some formulation of that problem that's obviously good, and there's some formulation of that problem that's obviously bad, right? So the government has no obligation to contract with Nazis, right? Right. Like if you're in government procurement, if you're in the military and you want to, you're in procurement, you put out a request for proposals, and Richard Spencer comes back and he's like the lowest bidder and blah, blah, blah. But also he's like an inveterate Nazi, right? You don't have to accept that bid, right? And no one would think the government should have to accept that bid. And no one would think that the court is going to like appoint a special master to oversee government contracting to make sure Richard Spencer gets a contract when he's the lowest bidder, right? And that's like obviously ridiculous. So then think about it from the flip side, right? The government says we don't accept contracts from businesses that are owned by Muslims, right? And obviously that's not okay. And the court can't use that as a preference in contracting, right? And so there obviously are things that the government can do through contracting and can't do through contracting, and is like stifling or sort of trying to depress the BDS movement, like one of those things that the government can do through contracting. Like probably, like I don't like it's like one thing to
how about if they want to stifle
what
I mean. Okay, go ahead. Sorry.
No, I was just gonna say it's one thing that like something that is like unambiguously covered by the free exercise clause. It's like one thing that, we should all just agree that the court's going to force the government to do that and do whatever it takes. It's another thing to say that like there's no limit to there's no limit to the prohibition on states' ability to socially engineer through its contracting authority, right?
How about if, I mean, I guess the Planned Parenthood example is one. Why is a lot of people would say, hey, listen, being able to stamp out Planned Parenthood is not that different from being able to stamp out BDS. Planned Parenthood isn't, I think most people would agree. Just say, listen, it's similar enough, right? No one's comparing Planned Parenthood to Richard Spencer, but if the government feels like morally speaking, it's got a problem with Planned Parenthood the way that it has a problem with BDS, then whatever.
Well, you may be right.
How's it different? I mean, I guess that's why I actually think like the government's ability to sort of stamp out. I think Tom's approach is maybe correct. As the Justice Breyer amongst us, to say, there are times where the government's preferences basically serve to sort of completely stamp out speech. You know what I mean?
Well, so there's on the Planned Parenthood example, right? There are like statutory reasons why the Texas government can't kick Planned Parenthood out of the Medicaid program, right? So the Medicaid program says that the government has to take eligible contractors, right? And
that's federal law, right?
Right. So the federal, but they're like federal statutory reasons why the state of Texas can't kick Planned Parenthood out of like a federal program. But like ultimately, should Texas be able to like kick Planned Parenthood out of like a totally state-based health services program? I mean, probably. There's probably no way around it.
Yeah, I'm troubled by the government saying, you are ineligible based on the fact that you say things we don't like, as opposed to, listen, you just would do a shitty job at this, and we're not going to select you for that reason.
If I can speculate a little bit, I feel like AJ is coming at this from, let's put the government in the shoes of a private contractor and let's let them do everything that a private company would be able to do, totally outside. You know what I mean? Like, let's put them on equal footing with a private company. But like, I think the government is different.
Yeah, I agree.
I don't think you can treat them like, exactly like a private contractor in even those areas where it acts or is doing a private like thing, like, employing people or contracting with other companies.
Yeah. Because so if you're a private company, right, you could certainly say, listen, I'm not employing any people that believe in BDS, like, I'm just not doing it. Or you could say, I'm not hiring anybody that has a, belief, like, that is a, that goes to, volunteer at Planned Parenthood. To me, it's quite problematic if the government were to do either of those things. And that's the same thing, right? It's a contracting thing, right? It's a labor contract.
Yeah. I mean, my view on this is similar to my view on people who say, well, the government's balance, sheet should look like a private company's balance sheet, right? Like, not necessarily, no.
But are you going to appoint a special master to make sure that like BDS advocates are getting government contracts? Like, how would you operationalize this?
Well, I think you would say that, like, I think you would just say, listen, government, you can't just exclude people solely because you disagree with their political view. If they're otherwise like, good. Now, obviously the court could go and say, hey, no, listen, like, or I mean, the government could be like, no, we're excluding them for another reason. And, that would be a fact issue, I suppose. But states do this all the time, right? Is they try and make it operationally difficult for the court to administer, decisions that the state disagrees with. So yeah, if you have to appoint a special master in this situation, then maybe you do. If the state continues to be intransigent.
But it's not even like this. I just don't see why we would need to appoint a special master or anything like that. Like in this scenario, like if you have a law that says, like take our universal health care example, right? Let's just assume for the sake of the argument that the universal health care is something that is totally pervasive and everyone, uses it, for their health and safety, right? Like this is like, if you don't have this, it's going to endanger your health and safety because this is the only form of healthcare left, right? Let's just assume.
I mean, look at Venezuela.
If the government were to pass a law that says, well, if you want to take part in our universal healthcare system, you have to not support Planned Parenthood, right? Or you have to not support BDS, or you can't be in the Tea Party or whatever, right? There's no special master that you would need. You would just look at the law. If it's a facial challenge and determine whether it's facially constitutional, you'd set up constitutional principles that govern, and you can take it by case in terms of the particular law that's passed. I mean, that's why we have our system of judges and courts across the country to do exactly this thing.
All right. Is there anything else we want to do?
It's a good discussion, guys.
Should we have an after show?
Oh God.
Is this
we have about 6 minutes, 5 minutes
to talk about cryptocurrency? So my cab driver yesterday, or my Uber driver, actually, she was asking me, what do you do? And I said, oh, I'm an investor or whatever. And he was like, oh, cool. Like, he's like, I've started buying a bunch of Bitcoin and Litecoin and Ethereum, and I was like, oh my gosh. And I tried to explain to him why. I was like, dude, that's totally fine, but you could lose all your money. And so he's like, man, I was supposed to go to this Bitcoin meetup 3 years ago and I didn't. And if I had, I would be a millionaire right now. And I was like, oh gosh. And then he said, in fact, there's this lady that I knew 3 years ago that did go to the meetup, and she put $3,000 in Bitcoin, and now she's probably a millionaire. And I was like, oh gosh, I don't know what to do here.
Is this your sidebar?
I guess so, but it's not a link of any kind, you know?
Sidebar doesn't have to be a link.
It's not something that... Oh, I thought it did.
No.
I thought we had to like give people like something to go check out.
Yeah, you definitely don't understand what a sidebar is.
I've never heard of a sidebar outside the context of our show. Like, do other shows do sidebars?
No. I don't think so. Sidebar, copyright 2017, Heartland.
Follow up, copyright John Syracuse at 1968.